Okay, which jail? Wow. Just give me the name. Yeah. Oh, I literally just picked up the packet to that one. Okay, what jail? Okay. All right. Good morning, everyone, to you. I'm Judge Nina DiPietro. I'm going to be presiding over your magistrate hearing. When you hear your name, come up to the podium, step forward, and we'll chat about your case. Some of the cases I'll be able to maybe resolve today. Some cases I have no ability to resolve, but we will take it one at a time. Just for purposes of doing this kind of make things quicker, if I could have everybody at the jail raise your right hand, at every jail. Thank you so much. Do you swear to tell the truth, the whole truth, and nothing but the truth? Are those yeses? I can't hear. Excellent. Okay. Good morning. All right. I have Mr. Swain. Is that correct?
That is correct.
All right.
On page 8 of your document.
Thank you so much. Good morning, Mr. Swain. I did review your probable cause affidavit. You're here on one count of petty theft, third or subsequent offense. Based on the affidavit, I do find probable cause. And do we want to, this looks like it's an ad charge, or is he's being held in for something else, I assume?
Yeah, Your Honor, he's being held no bond on a couple felonies that his bond was revoked in those cases.
Okay. All right. Well, I guess it probably would just be a conversation of academics regarding the bond. Is that true?
Yes.
He's being held no bond. All right. So I'll leave the bond at $750. Anything further for Mr. Swain?
Not from the defense.
Okay. Thank you. Okay. I have.
Judge, the deputies are requesting if we could call another gentleman out of turn. Sir Keatron Batten. He's approaching. Judge, going to be a little bit. He's in a wheelchair. Hold on one moment.
What's the last name again?
Batten, B-A-T-T-E-N.
Okay.
He's on page 16 of your document. So
Okay.
He should be probably in the middle of your pile.
Okay. I will keep looking. Got him. Okay. Hi there, how are you, sir? All right, Mr. Batten, you're here on a bunch of counts. Let me go ahead and I'll read them and then we'll have a chat. First is possession of a weapon or ammunition by a convicted felon. There's actually 2 counts of that. Third is committing a second-degree felony with a weapon. Possession with intent to sell or manufacture or deliver cocaine, aggravated assault with a deadly weapon without intent to kill, burg, dwelling, structure, or conveyance armed, grand theft 5,000 or more, but less than 10,000, grand theft 300 to 5,000. Does he have a second sheet? And you also have an out-of-state hold. Based on my review of the probable cause affidavit, well, first of all, we have a couple things that are there by warrant. So whatever's there by warrant obviously has probable cause. That's already been a determination. I like to hear from the parties regarding the possession with intent, and then obviously that would then flow over to the second-degree felony. I saw that there was individually bagged little baggies, but from my understanding of the case law, I don't think that's enough for possession with intent without an admission or something else.
I would agree, Judge, and I don't think that the amount is specified as being the kind of amount that we would typically see in intent with possession with intent to distribute.
Well, I don't know that amount in and of itself, or...
I mean, it depends how much was sold, but, Your Honor, I would also note
If any.
It would also note that and that's why the deputy also mentions he was in possession of $260, all in small denominations, consistent with street-level narcotic sales. The money was kept separated and arranged in denominations easy to provide change.
And my money in my wallet's separated, too. I don't think that that has anything to do with somebody selling drugs because they have $260 in their wallet.
Yeah, I mean, I can say, I think that it's close, but no cigar. You know, I think that it's too many assumptions that you have to make for purposes of probable cause. I mean, certainly there's probable cause for the possession of cocaine.
Well, Your Honor, also noting several small, I mean, that it's also several small baggies. It would appear that's packaged for sale, Your Honor. It's not, if it was all the substance in one bag, I would agree, because there's no, wouldn't it be appearing means of selling it, Your Honor?
Well, but and I'm just going off memory. I'm pretty sure there's case law that addresses that exact issue.
Yeah, if that's all there is, but combining that with the currency. I mean,
I don't know.
everything has to be taken together.
Here's the thing. I'll give you time to perfect it if you want.
Okay.
I'll definitely find probable cause for possession of cocaine. As it relates to, I think necessarily then I can't find probable cause as it relates to committing a second-degree felony with a weapon. I don't know if is there a charge for committing a third-degree felony with a weapon? That would be probable cause if there is such a crime.
One moment.
I mean, we're going to have to obviously talk about the other charges as well. But as far as probable cause, I mean, the other charges, the 2 counts of possession of weapon or ammo by a convicted felon, that I find probable cause for.
Yes, there is possession of or use of a weapon while committing a felony. In the case of felony of third degree, it would be a felony of the second degree.
Okay. Well, so I'll find
I'm not going to be asking for any time.
What's that?
I'm not going to ask for any time.
Okay. So what I'm going to do is I'm going to find probable cause as it relates to committing a third-degree felony. I don't know if it just says a felony versus a third-degree felony, but committing a third-degree felony. And then as far as the possession with intent, I'll find probable cause as for possession of cocaine. And so those I'll find probable cause for. Obviously counts 1 and 2 I find probable cause. As it relates to the other counts, those are through warrants. So if you want to have a chat about bond for all of the counts that we need to address. And I do have the arrest affidavit for the other counts. Yes, they're all in one arrest affidavit.
This is good. What's that? No, I got something else. What's that? Sure. Judge, you have the affidavit, correct?
I do.
Yeah.
Yeah.
I know she does.
So just let me know whenever you're ready as far as your...
Oh, no, I'm sorry, Your Honor. I was ready.
Yeah, no, your position on bond for
Your
all
Honor,
the counts I have to set.
Okay, I'm sorry. I thought you were, on the armed burglary, the state would be seeking a no bond, Your Honor. On the PBL, based, for first appearance purposes, only a finding of proof evident or presumption great, based on the allegations in the warrant affidavit.
Okay.
Your Honor, on count 3, even though it is, you found it would make it a second degree instead of a first degree, I still would be asking for the standard bonds, actually on 3 and 4, to be kept in place, noting that there's another allegation before the court with Mr. Batten in possession of a firearm and committing a burglary and threatening someone. Also noting, Your Honor, in regards to the bonds on those charges, Mr. Batten is currently out on bond for a felony. He's out on charges of trafficking in cocaine, corruption by threat, fleeing and eluding, DWS habitual offender, leaving the scene of a crash, misdemeanor possession of cannabis, possession of drug paraphernalia, and I would note that Mr. Batten additionally has 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 prior felony convictions out of Broward County. He's previously been sentenced to Florida State Prison, and noting that he also has an out-of-state hold for burglary and burglary-related offenses.
So he's currently out on bond on another case. Can I have the case number, and we'll
Yes,
deal with that
Judge.
as well?
It is 173030 CF10A.
Okay. All right. As it relates, what is your recommendation for bond on counts 1 and 2? I know obviously you are asking for no bond
I'm
on.
sorry.
That's okay.
Yeah, 1 and 2, I would be asking for $10,000 on count 1 for the gun, on count 2, $1,000 for the ammunition, and everything else. I'm just asking that they be left as previously said.
Okay, Mr. Reedy or Mr. Romero, whichever.
Judge, I don't know if my colleague has a specific argument as far as count 6.
Okay. Well, you guys can both argue if you want.
Well, there's been no finding as to count 6 yet, so I don't have an argument at this time. The state has not, to the best of my knowledge, made any requests of the court.
I believe
Yeah,
I did.
he did.
Oh, I'm sorry.
Oh, yeah, he did. He asked for a no bond hold based on proof evident presumption great.
In light of the fact that Mr. Batten has a no bond hold on an out-of-state hold from the state of Illinois, we would reserve any argument regarding proof evident presumption great until he appears in front of his division judge.
Okay. And Mr. Romero, did you want to add anything at this time?
Judge, considering at this time he has the out-of-state hold, he's out on case, which the state has mentioned. The only inquiry we would have as far as in count 6, when's the alleged date of incident on count 6?
Sure. Give me 1 second.
It is-
November 3rd.
No,
Right? Am I correct on that? Yes.
I think
Judge, having learned that information, that was something we wanted to know.
Okay.
Counts 1 and 2 would be requesting just a $1,000 bond. It's all academic. He's being held no bond. We'd ask you, since you only found probable cause for the for a lesser on count 3 and a lesser on count 4, we'd ask you to reduce the standard bonds, which are currently set at $7,500 for one of the counts, $2,500 for the other count. Reduce it to $5,000 on count 3 and $1,000 on count 4, Judge. That would be the standard bond on the possession of cocaine.
Okay. All right. Well, what I'll do is this. First, I'll address counts 1 and 2. Counts 1 and 2, I am going to grant the state's request for a $10,000 bond on count 1 relating to the firearm, $1,000 on count 2 as it relates to the ammunition. As it relates to 3 and 4, I will reduce the bonds to the defense request of $3,000 for count 3 and $1,000 for count 4, based upon my findings of probable cause to lesser crimes. As it relates to count 5, I'll leave the $7,500 bond. As it relates to 7 and 8, I'll leave the $5,000 each in place. As it relates to count 6, I will be holding the defendant no bond based on my finding of proof evident or presumption great. And as far as case 17-3030 CF10A, I'm going to be revoking your bond pursuant to Florida Statute 903.0471. Good luck to you, sir.
And, Your Honor, the other thing I'd ask, in an abundance of caution, I'd ask for an order of no victim contact with regards to the ag assault armed burglary case.
Okay, so no contact with any alleged victims in the cases.
All right, your next court date is February 8th in front of Judge Fine, sir.
All right, and I'm sorry, I didn't mention it, but he does have that out-of-state hold. That's a no bond. Okay. All right, are we ready to start, or are there any further that we need to take? Hi, welcome.
Good morning, Your Honor.
Good morning.
Handel Edwards with the McLawrence law firm.
Okay.
Before the court begins to docket, can I call one case
Please,
on
yeah.
Ms. Alvaro Tinoco on page 10 of the docket?
Okay, let me just find it. Do you know what jail? Do you know where
I
that
am not certain, Your Honor.
Tinoco?
Okay.
He's coming up, but he's all the way in back, Judge.
Okay, that's okay. Take your time.
He's approaching, Judge.
Okay. All right. Good morning to you, Mr. Tinoco. You have your attorney here, Mr. Edwards, so I hope you can see him. You're here on one count of possession of cocaine, one count of possession of buprenorphine, one count of resisting an officer or obstructing without violence, one count of false identification given to a law enforcement officer, one count of possession of drug paraphernalia, tampering or fabricating with physical evidence, and you also have a capias on a felony case from 2016. Looks like you have 3 separate charges on that one. A misdemeanor capias for a municipal ordinance, and also an immigration hold that's going to hold you no bond. So as it relates to the bondable offenses, I do find probable cause based upon my review of the probable cause affidavit. Did you want to make any probable cause arguments or just bond?
No, Your Honor. So we are seen to be appointed to the capias for the misdemeanor for
Okay.
the MO.
Municipal
and
ordinance,
we'll handle
sure.
it in the division.
Okay. So let me take a look here and see what it is.
It's for petty theft.
Okay, hold on. Let me see if I can find paperwork
Okay.
that might describe it. Hold on. Okay, I do see it. It was a no-show at arraignment, so I can't change the bond, which is $500. I don't have any sort of probable cause affidavit. I'm not sure what happened there. I just have the arrest warrant. Is he looking to resolve it, or based upon the other holds, is he looking to maybe deal with this at a time where he can better seek advice?
Judge, we
Exactly.
represent Mr. Tinoco, I believe, on his other charges.
Okay.
He's got several no-bond holds from Judge Merrigan. So at this point in time, it would not be in his best interest to resolve the petty theft.
Okay.
Exactly, Your Honor.
Okay, no problem. All right, and I'm just looking at the capias from, was that from missing a court date, or do I need to set a bond on that, on the 16 felony case? Oh,
It's court order, failure to appear.
okay, all right. Well, it just is unclear on the capias here.
Yeah.
Okay, all right. So what we'll do is this: I'm gonna leave the bonds in place. 1,000 count 1, 1,000 count 2, 100 each for counts 3, 4, and 5. I don't have to set a bond for 6, 7, $1,000 on 8. There is the no bond hold on 9 and 10. There's also the no bond hold. $500 on the municipal ordinance case, and then the no bond immigration hold will stay as is. All right, good luck to you, sir. Thank you so much
Thank
for
you, Your
coming.
Honor.
Is there any other municipal ordinance case you'd like to call?
That's all we have today. The other one's bonded out.
Okay, all right. Take care. Thank you.
Thank you. Have a good day.
All right, any other cases out of order? Yes, no? All right, we'll start with Monica Sarekite.
She's in North Broward, Your Honor.
All right, good morning to you, ma'am. You're here on one count of criminal mischief, one count of battery on a law enforcement officer, firefighter, or EMT, and one count of resisting an officer or obstructing with violence. I did note that there's no amount on the criminal mischief. I mean, let me see what it was.
It was a screen door, I believe.
Yeah. I don't know how much screen doors cost.
Yeah, I mean, Your Honor, obviously, as far as the criminal mischief, PC can be found for second-degree criminal mischief.
Okay.
I'm really not concerned about the bond on that
Okay.
count.
All right, so what I'll do is this. I'm going to find probable cause for second-degree criminal mischief. I do find probable cause on the other 2 counts based on my review of the probable cause affidavit. And what is the state's recommendation for bond
Your Honor, I'm going to be...
or pretrial release?
Well, my only concern, pretrial release, I don't see any kind of address. I don't know that she is...
Here's the situation, if I may, Judge.
Please.
How do you pronounce your last name, ma'am?
Seretskita.
All right.
Sarah
Monica is from Lithuania, Judge.
Okay.
She doesn't really seem to have any ties to the community. I was able to speak with her, but it could have been a better conversation.
Do we need an interpreter?
Well, that's the question I was going to ask. Monica, do you speak either Polish or Russian?
No.
Okay. It's going to take 48 hours to get a Lithuanian interpreter.
But
So,
pretty good.
yeah, I think your English is pretty good. I was able to understand what she was saying. And if it wasn't 48 hours, maybe I'd have second thoughts about it. But that's a long time for her to wait.
Let me ask you this. For purposes of giving her a potential opportunity to bond out, could I set a bond, but also put a note where if she does not bond out, she's brought back within however long it takes to get a Lithuanian interpreter? Is there a,
Yeah, what you could do, set bonds without prejudice and then reset her.
okay. Because I want to give her a chance to potentially get out and, you know, have an opportunity to do that, but also not take away her opportunity to, you know, use an interpreter and maybe have a more meaningful bond hearing.
She has $100, Judge.
Okay.
I'm sorry. He misunderstood.
No, go ahead. Go ahead.
When we spoke about hotel prices, say 100, it totally have 2,000, more than little.
How much money do you have access to, Monica?
2,500.
2,000?
500.
And where is this money? How are you going to get a hold of this money to bond yourself out?
My own stuff and my money is with the police, where they take the luggage.
All right. If the judge was to set a bond, say $1,000 total, would you be able to bond out with the money that you have?
Yes, and like even today, I mean, I don't know what the process is.
You know that you would have to come back to court for these charges.
Yes, because my...
All right. Judge, I'd ask you to consider $500 on count 2, $500 on count 3, and an ROR on count 1, and set her for a second look docket on Friday afternoon.
Okay. There's no address information or anything, so if she is released, where would they send the
She
notice?
was staying in a hotel, Judge. She's here on holiday.
Oh, okay. All right.
And she got in, well, you read the probable cause affidavit. She got in a
Right.
fight with this fellow, and then I guess that carried over to the contact with the police.
Got it. Okay. All right. Mr. Linder, your position, I saw you.
I think for someone that we have absolutely no address to send a court notice to, I think 1,000 is a little low. I was going to be requesting a $2,000 bond total. We got 2 third-degree felonies.
All right. Well, here's what I'm going to do. I'm going to set a bond I'll set a $1,500 bond total. So on the criminal mischief, $200, which I found probable cause for second degree, I'm not going to require any bond on that. On count 2, it'll be a $1,000 bond. On count 3, it'll be $500 bond. And what I'll do is I will also have her come back. We'll see if we can get an interpreter, and perhaps in between then, maybe, I don't know if she's applying for the public defender's office or if there's going to be any chance for her to speak with an attorney, but maybe they can get some contact information or some plan for her release if she can't make the $1,500 bond at this point.
I'll have somebody go see her between now and
Okay.
Wednesday, and I'll let the interpreter's office know to have a Lithuanian interpreter on standby for Wednesday afternoon in case,
not
Friday
Wednesday.
afternoon in case we need one.
Okay.
All right.
Okay, so ma'am, what I'm doing is I'm setting your bond
PM,
at
yeah.
a total of $1,500, okay? If you can bond out, if you can pay that and get out, you need to keep checking back with the court system to see if you have a court date. And as soon as you have some sort of idea of what address you're going to be present at, you need to let the court know so they can send you information. If you're not able to bond out on this $1,500, you're going to come back and see me. I'll be here again Friday afternoon, and we'll have a Lithuanian interpreter who can better assist us, and also an attorney is going to come visit you between now and then. Okay?
Your Honor, the only other thing I'd ask is in order that she not have any contact with Emil Marinescu.
Okay, and also you can't have any contact with that person. So don't try and call them or contact them. That would be a violation of your bond or your pretrial release conditions, okay? All right, so
Okay.
if you can get out, you'll get out. If not, a lawyer's gonna come see you, and we'll have an interpreter here Friday afternoon for you as well.
All right, Monica, if you have that money in your property, you can tell the deputy that you can self-bond.
I mean, I would like to pick up them myself from the place where from the luggage where they are with policemen, and then I can bond it now.
Okay.
Okay, good luck to you, ma'am. All right, I have Maria Bracero next.
Julianne, Judge, she's here present, Judge Maine.
All right, good morning to you. You're here on one count of grand theft, 300 to 5,000. Based on my review of the probable cause affidavit, I do find probable cause. Is she a candidate for pretrial or can she bond?
Judge, we were going to be requesting actually pretrial. Unfortunately, Ms. Bracero, she's a mother of two kids, ages 9 and 8. Her and her husband live in a motel here in Hollywood. In Dania Beach. Unfortunately, because of circumstances, they lost the house that they were renting at for almost 2 years in Hollywood.
Okay.
Her husband works in construction, making about $10 an hour. Financially, right now, he can't afford to post a monetary bond. She's the one that takes the children to and from school. Judge, we'd be asking you to consider releasing her pretrial release.
Okay. Does she have priors or anything that would prevent her?
We were unable to make a verification on her behalf.
Okay.
We did contact the name of her husband, John Curtis, and we're unable to verify any information, so I'm not making a recommendation for her.
2011, she had 2 counts of child neglect. She received withholds. I'd also note this isn't a situation where property was recovered. It's based on this, in the past 20 days, she stole approximately $1,200 that was never recovered.
Okay. All right. What else?
Judge, as far as the prior, I believe that Mr. Lender was referring to, my understanding is she received the withhold. She was placed on probation.
Yeah.
She successfully probation. I believe she even was early term. So she shows the pattern of being able to be supervised, and that's why I think she may make an excellent candidate for pretrial release.
All right. Well, this is what I'll do is I'll put the bond at $500. So if she can try and make that bond, she can. And I'll do one of those orders that says that if pretrial can verify an address, maybe if she can give them a little bit more information or her husband has more information, if pretrial can verify the contact information and a place for her to go, I'll let her out on pretrial, just regular pretrial, no GPS or anything.
Your Honor, regarding the fact that I believe she lives in a hotel, is the court open to release her to reside in that hotel? Because typically we consider that to be transient housing. Is the court saying that we do verify that she lives at the hotel, wherever that's okay?
Yeah, that's fine. And if it requires, if she has to move and therefore she can't receive information there, then I'll require her to report in person versus you guys sending stuff to her. So, ma'am, yeah, go ahead.
I was just trying to talk to Ms. Bracero. I believe the reason why maybe they are having a hard time contacting the husband, my understanding is the phone may be disconnected. I believe they may have not been able to pay the phone bill. I believe that's why it's disconnected, but they're staying at Motel 6, which is in Dania Beach. So I don't know if,
I think they may have. Did you speak to him?
Your Honor, we did not speak to him. The phone rang and the voicemail engaged, and I left a voice message.
Okay.
It was not disconnected.
And if necessary, pretrial, you guys can send a team out there, correct? Okay, so they can go physically out there. They don't have to just go by telephone. So.
Okay. All right. Well, if pretrial can verify, they have not been able to speak to him, but they did say they left a voicemail. So if pretrial can verify where she'll be residing, then I'll let her out on pretrial ROR.
Judge, now I know.
Hold on one second. I have 2 people talking at once, so hang on one second.
I can't hear the other person.
Me neither. Yes.
And you said as long as she lives, even if she's living in a motel, that's fine with the court, correct?
Yeah. If she has a place to live, and if she doesn't, then she can report in person to you guys, just like we do when people don't have a home. Okay. So I'm going to sign the order that she can go on pretrial, just regular pretrial, pending verification. She'll be permitted to live. If she's living in a motel, that's okay. Ma'am, if you move from that hotel, if for some reason you can't stay there anymore, you need to be in contact with pretrial. You need to explain the situation to them. If you have an attorney, whether it's a public defender or a private attorney, make sure that they talk to the court about the situation and keep everybody appraised so that you're not in violation of any conditions. But I'll let you out on pretrial. You have to obviously come to court. Don't pick up any new cases, no new arrests, nothing like that. But if, I'll try and work with you as far as being able to get you out, so long as you can come back to court, okay? Okay. All right, good luck, ma'am. And I did change your bond to $500. So in the event that she, for whatever reason, posts a bond instead, it's now $500.
Thank you, Judge.
Okay, all right. Are you guys here on a specific case, all of you, or some different people? Okay. All right, well, if you just want to let me know what cases they're here on, I'll call them out of order. All right, Melissa Moran or Moran? Hi there, ma'am. Good morning to you. You're here on 1 count of possession of heroin, 1 count of possession of buprenorphine, 1 count of possession of drug paraphernalia, and you do have a probation violation, no bond hold on that. As it relates to counts 1, 2, and 3, I do find probable cause based upon my review of the probable cause affidavit. It probably makes sense for me to just leave your bonds as they are, 1,000 count 1, 1,000 count 2, no requirement for count 3. Okay, so count 4 is actually a Palm Beach. Is it a probation case or a regular case? Okay, so your count 4, the probation hold is not Broward probation, it's Palm Beach probation. So that has been, I guess, changed in the system to note that it's Palm Beach County. But you're being held no bond on count 4. So you can bond out on the Broward cases, and then Palm Beach can make a decision as to whether they want to transport you. But you won't be able to get out altogether without dealing with the no bond hold from Palm Beach. Okay? Do you understand?
Sort of.
Okay, so you've got 2 separate things holding you. You have 2 new Broward charges, or 3 new Broward charges, which is 1 case. Okay, those are bondable. You can bond out for $2,000 on that. However, you have a no bond hold, but that's Palm Beach County. So if you bond out on the Broward stuff, then Palm Beach County can come and get you. If you don't bond out on the Broward stuff, then you'll be dealing with the Broward stuff, and then once that hold is resolved, whether it's by plea, trial, or some other type of ruling from the court that resolves that case, then Palm Beach will come and get you. So probably best idea if you're going to have either a public defender or private attorney, talk to them. They can tell you strategy-wise what's best for you to deal with first, okay? All right, good luck. Okay. All right, Dominique Massey.
Chairperson, Judge at Maine.
All right, good morning to you, ma'am. You're here on a violation of probation case. It's a no bond hold. You have a hearing on the 18th at 9 a.m. So the 18th, you'll go to court. Thank you. All right, Aranetta Sanders.
Still on loan, Judge.
Okay, medical loan. Bradley Vaughn.
He is downtown, Judge, in courtroom 5165.
Okay, so what do we want to do with
I'd
him?
reset him for tomorrow.
Okay, that's fine. So can we reset this one for tomorrow? Thank you so much. All right, Christian Nelson.
He's here, President, Judge at Maine.
Okay, good morning to you, Mr. Nelson. You're here on 1 count of trespass. Based on my review of the probable cause affidavit, I do find probable cause. There's a $25 bond if you want to bond out, or I can make an offer to you this morning to resolve the case if you want.
I'll resolve the case.
All right, raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay, all right. All right, so it looks like it was an apartment complex. Yeah, all right, don't say anything, all right, sir? I know you're resolving your case, but still, everything you say is being recorded. All right, if you want to resolve, does he have priors?
So
Does he have prior convictions?
I was only able to check Broward. He had a withhold on a theft in 09.
Okay, anything else that would be?
I don't know, frankly.
Okay. Is he from here? Does he live here?
Yeah, no, it's just in my system, they for whatever reason, they didn't put him on the list of defendants.
I have 0 months of residence on here, but that doesn't mean anything. Mr. Nelson, how long have you lived in Broward County? Or if
10 years now.
10 years now, okay, all right. All right, well, what I'll do is this. I'm willing to offer you withhold of adjudication plus court costs in recognition of your time served. I'm basing that off of the fact that we've only been able to verify 1 prior on your record, and that was a withhold. So I don't want to put a conviction on your record if it's not something that it rises to the level of. You will not be able to go back to Parrott's Landing apartment complex. So if you go back there, you're going to get in trouble. So don't do that, okay?
I'm not going back.
Okay, great. All right. So do you want to enter a plea of no contest to this charge?
Yes, I will, ma'am.
Okay. Are you doing this freely and voluntarily?
Yes.
Is that
voluntary?
okay? Is anybody forcing you or making you do this?
No.
Okay.
Not at all.
All right. Give me 1 second. And you understand you're not going to have a trial or fight the charges if you enter this plea today?
Yes, I do, ma'am.
Okay, all right. You're going to have 6 months to pay your court costs, so talk to the clerk's office about that when you get out. Withhold court cost recognition for time served. Thank you. All right. What cases are they here on? I'll call them. I'm double checking them. Oh, okay, great. Yeah, let me know. Curtis Trailer.
Medical reset now.
You got it. Medical reset on Mr. Trailer. All right, Andre Vegas.
Also medical.
You got it. Ellie Menashe, or I might be saying that wrong.
He's here, President Joe.
All right, how do I say your last name, sir?
Mr. Minash.
Minash. Okay, Mr. Minash, you're here on 1, 2, 3 outstanding capiases. There are 4 total counts. Let me take a look at what they are. All right, so it looks like you didn't show up for an arraignment on a trespass. That's a municipal ordinance case. You also have another municipal ordinance case where it was no show at arraignment for 2 separate charges. And then you have a final traffic no show at arraignment for unlicensed tag or sticker attached. Do you want to resolve these cases today, or you want to try and bond out?
Yes, ma'am. I would love to resolve the cases today.
All right, raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay. All right. To resolve these cases, I'm going to give you an offer of an adjudication, time served, and court costs. You're going to have to pay court costs for each case. So do you want to resolve your case today, knowing that on all the cases there will be an adjudication, which is a conviction? You don't have to. Yeah, so there are 3 separate municipal ordinance charges, and then you have 1 traffic. But they're still on your record.
Okay.
Is that what you want to do? Does he have priors?
Yes, as far as Broward, he had a felony possession of cannabis, drug paraphernalia.
Adjudication?
Got a withhold on that. Misdemeanor possession of marijuana and DWLS.
Any adjudications?
No, but I mean, it's.
Okay.
I think at some point, yeah. I mean.
Well, yeah. I mean, here's the thing, sir, is that from what we're looking, based upon the limited information we have of your criminal record, you don't have any convictions on your record. If you resolve these cases that we can see for right now, you may, and we just don't know about it. I'm not sure, or you may not. But if you want to resolve these cases, it would be to an adjudication, which is a conviction. The reason for that is because you have multiple outstanding cases where you haven't been showing up to court, and it's just again and again and again. I mean, we have 3 separate incidents here of you having separate cases and not coming to court. Okay, so as far as the, it looks like they're all 2017. It looks like maybe a string of separate incidents, and that to me, gives rise to an adjudication based on that and your prior record. So if you want to resolve the cases, I will, but it'll be a conviction on your record.
Okay, I would love to resolve the cases. Can I have a year to pay the court costs?
I can do that. All right, so do you want to enter a plea of no contest?
Yes, ma'am.
Okay, all right. And are you doing this freely and voluntarily?
Of course.
Okay, well, you say of course. It may not be of course. Is anyone forcing you or making you do this?
Not at all.
Okay, all right. And you understand you're not going to have a trial or fight any of these charges of these 3 separate cases?
No.
Okay. You're good?
If I take them to trial, would I still be able to be released?
Well, you have bonds. Yeah, I mean, you have bonds on all of these. You can bond out and fight them. I mean, if you're inclined to fight them, then don't resolve them today.
All right, no, I'm okay. I'll just resolve
Because I'll tell you what, I'm not going to change the bonds on them because you have a consistent pattern of failing to appear. You have $550 total in bond for all of it. So I'll let you bond out on them. That's fine with me. I don't have a feeling one way or another.
I'll just take the charges, ma'am.
All right, you understand that by entering this plea, though, you're not going to have a trial. You're not going to be fighting this. This is all going to go on your record, each of these counts of the cases.
Yes.
All right. All right, I'll give you an adjudication on each case, each count, plus recognition for time served, plus court costs. You have 1 year to pay.
Yes, ma'am.
All right, good luck to you. All right, thank you. All right, I have Gregory Buckles.
He's a North Broward judge. He'd like to resolve his case if possible.
All right. Hi, good morning to you. You're here on 1 count of trespass. Go ahead and raise
Yes.
your right hand as best you can. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
All right, sir. Thank you so much. Like I said, you're here on one count of trespass. It's my understanding you want to resolve your case, or do you want to try and bond out and fight it?
No, I want to resolve it.
Okay. Does he have priors?
Yes, Your Honor.
Okay. I see a bunch of aliases. Any convictions? All right.
Yes, he does have
And,
conviction.
all right. So what I would offer you is an adjudication, recognition for time served, and court costs. Okay. Now here's the thing. From what the allegations are, I'm not sure if they're true or not. You're telling me you want to resolve the case today, but it says here that you keep going back to the library after being trespassed. You cannot go back to the library. Okay. You got to go somewhere else. Do you understand that?
Yes.
All right. So, do you want, if you want to fight your case, we can talk about bond and we can see if you, no? All right. All right. Are you doing this freely and voluntarily, or is someone forcing you or making you do this?
No.
Okay. All right. You understand you're not going to be fighting the charges. There won't be a trial, anything like that.
Yes.
All right. Do you want to enter a plea of no contest in exchange for the adjudication, court costs, and time served?
Yes.
All right. So I will accept your plea. It's going to be an adjudication plus court costs plus time served. I'll give you a year to pay the court costs, okay? Make sure you pay your court costs and absolutely no return to the library, okay? So don't go back there or they're going to pick you right back up and bring you back here. You know they're going to look for you, all right? All right, good luck to you, sir. Hi, how are you? What are you here for? Oh, the Lithuanian thing? Okay. We asked. She said not Russian and not Polish either. Yeah. Yeah, I gave her a bond, and she's saying that she has money in her possession to bond out, so it's very possible she bonds out. But if she doesn't, that's why we set it for Friday, so that you guys would have enough time to... Okay. I understand. Just, we'll keep in touch as far as, and you might want to just kind of track her in sheriff.org or talk to confinement status because she might be bonding. Yeah. Got it. All right. Well, why don't we do this? Why don't you see if you can locate one, and then we'll kind of reassess it tomorrow. Okay?
Your Honor.
Yes.
I don't think, can you go off for me? Can you go off the record?
Yeah. Sir Kenneth Carver?
He's here, President Main Judge.
All right. Good morning to you, Mr. Carver. You are here on one count of obstructing a highway. Based on my review of the probable cause affidavit, I do find probable cause. I think it was a panhandling situation, if I remember.
Judge,
Yes.
Is this a state charge or a municipal ordinance? Or city?
State?
It's a state charge.
It's not a municipal ordinance.
It's a state charge.
Yeah, it's state. All right. Does he want to resolve this case today, or does he want to try and bond?
Mr. Carver wishes to ask Your Honor if he wishes to resolve it for time.
All right. Raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right. Great. All right, Mr. Carver. Does he have priors? Any convictions?
He has a lot of priors. I'm just trying to see something, Your Honor.
Okay. We're just going to take a look at your record so that I can make you an offer.
Yes, ma'am.
Shooting at or throwing deadly missiles. No. Yeah, Your Honor, he's got a lot of priors. He was just convicted last month of shooting at or throwing a deadly missile. Got 180 days county jail on a habitual offender, qualified as a habitual offender, and It was released November 15th.
Okay. All right. Well, what I'll do is this. I'll offer you, given the nature of the offense, I'll offer you an adjudication, time served, court costs. I can't do anything about court costs. That's always required. I guess you were at an intersection. Okay. All right. So if you want to resolve your case, that would be the offer.
Time served, adjudicated guilty?
Mm-hmm. Is that what you want to do?
Yes, ma'am.
All right. You want to enter a plea of no contest to the charges?
Yes, ma'am.
All right. You understand that you're not going to have a trial or fight the charges if you resolve it today?
Yes.
Are you doing this freely and voluntarily?
Yes, ma'am.
All right, I'm going to give you an adjudication plus court costs plus time served. You have 1 year to pay your court costs.
Thank you, thank you.
All right, good luck. Stay out of trouble. All right, Logan Estlow.
Mr. Eslo, come on up, please. He's approaching, Judge.
Thank
He's
you.
your main.
All right, Mr. Eslow, you're here on 2 counts of DUI. The first one is DUI alcohol or drugs, and the second one is DUI enhanced based upon either a breath or a person under the age of 18. I find probable cause for count 1, but I don't find probable cause for count 2. I didn't see a breath, and I think it said he was the sole occupant. Yeah. I think they meant to put an accident, DUI accident, and they probably hit the wrong button. But
That could be, but that's not what
yeah.
it says.
In any event, I don't find probable cause on count 2. Mr. Linder, I don't know.
I'm not asking for anything.
Okay. All right. What I'll do is, so there's going to be no PC on count 2. Count 1 only. No PC. State is not asking for time to perfect. So as it relates to the bond, Mr. Romero, did you want to tell me anything about bond?
Judge, that's what we're gonna try and see if maybe on count 2 you could reduce it, but since no PC's found, I think he said his mom may be able to come up with the $500.
All right, well, given that it's an accident, I actually am gonna consider a higher bond on count 1. I mean, there's gonna be no bond requirement on count 2, but I'm not gonna leave $500 in place. I'll give him well, does he qualify for pretrial, or he is? Okay, can you, Mr. Linder, does he have any priors or anything, or you think he might be a candidate? Okay. All right. Well, I can do what I can do is I can release him to pretrial if they can verify, if they can get in touch with his mom. Maybe we have a better phone number or something we can.
We left a message for her this morning at 8:27.
Okay. So they left a message for mom about an hour ago. If they can verify, I'll let him out on pretrial without any bond requirement.
Let me inquire, Judge.
Okay.
That would be fine, Judge, with pretrial.
Okay. All right. So I am going to ROR him to pretrial.
And, Your Honor, and it wouldn't change anything with regards bonds, but reading it again, I think where the arresting officer might have made a mistake was the intention was a DUI property damage.
We already said that.
Okay, I missed
That's
it.
okay.
Sorry.
Don't worry. I figured that was the case because I did see there was an accident and no charge for the accident. All right, I'm going to ROR him to pretrial. Good luck, sir.
So he's no longer pending verification.
Well, don't you have to verify his address to release him?
So then he's not an ROR, then Your Honor, he's just pending verification, and the bond remains in place.
Okay, so then what I'll do is I'm going to give him a $750 bond, and if pretrial can verify, that bond requirement will go away and he'll be ROR'd to pretrial. Okay?
Thank you. And Your Honor, that would be with the drug and alcohol evaluation and random urinalyses as well?
Definitely the random urinalysis. This is a first, right? No requirement for what do you call it?
Alcohol evaluation.
An evaluation at this point. But yeah, you can't have any alcohol or drugs while you're on pretrial release. Okay, sir?
Okay.
All right. Good luck. All right, Michael Evans.
I've been informed he bonded.
Okay. Jonathan Paul Lamore.
He's coming up. Judge, me as well, please.
All right. Good morning, sir. You're here on a municipal ordinance capias. Let me take a look at it. Looks like it was a trespass and that you showed at arraignment. Based on my review of the probable cause, well, there's a capias, so there is probable cause. Do you want to resolve your case today, sir, or do you want to try and fight the charge?
Resolve it.
All right, raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right. Does he have priors?
One moment. Is this Emma? Who is this, Your Honor?
This is last name Paul-Lamore. It's a MO trespass. Thank you.
I don't see any priors. The only thing I would advise the court, and it really has more to do with colloquy.
Yeah, it looks like
Resolving it.
he's from Canada.
Well, I've seen he was picked up multiple times by Customs and Border Patrol in New York for
Okay.
entry without inspection, unlawful entry.
right. All right. So here's what's going on. You have a bit of a complication potentially, so we can talk about this. You have the opportunity to bond out. There's a $100 bond. I'm not allowed to change that bond, but you have the ability to bond out and fight the charge because the concern is that you might have a potential immigration complication. Your record is showing that you've been picked up a few times regarding immigration issues, so that leads me to believe that it's a possibility that you may not be a U.S. citizen or have ability to stay here, especially if you have something on your record that shows that there's criminal activity, okay? So what I can do is this. I can offer you something to resolve your case today. However, with that being said, you would have to understand that I'm not an immigration judge. I don't have an immigration attorney here that can advise you of immigration complications and the different potential consequences. I can say that it's a possibility that you could be deported. That's always a potential issue if someone's not a U.S. citizen, okay? Now, do you want to resolve your case or you want to try and bond out and fight it and speak to an immigration attorney as well?
No, I resolved it.
All right, so raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay. All right. I'm going to offer you a withhold of adjudication, court costs, and recognition of your time served. Okay? So that's in exchange for a no contest plea. Is that what you want to do?
Yes, ma'am.
Okay. I'm also going to require you not to return to... You know what? I don't even have the location.
Is there an address?
Well, it was a capias they picked him up on, so...
What's the case number?
16?
Yes.
5531 MO40A. All right, so there's also going to be a no return to the premises that you were trespassed from, okay?
And it's showing...
All right. 5595 Pembroke Road. Don't go back there, okay? All right. Do you understand that by entering a no contest plea and resolving your case here today that you're not going to have a trial and you're not going to be fighting the charges? Do you understand that?
Yeah.
All right. And do you understand that, as we talked about, I have no idea what this could do to your immigration status, that there's a possibility that you could be deported based upon accepting of this plea today. Do you understand that?
Yeah.
Okay.
Yes, ma'am.
All right. And are you doing this freely and voluntarily?
Yes, ma'am.
All right. Is anybody forcing you or making you do this?
No.
Do you want to have the opportunity to speak to an attorney, and even an attorney that, can advise you as it relates to immigration consequences before you enter this plea?
No, thank you.
Okay. All right. Well, I will accept your plea as freely and voluntarily given. I'll give you a withhold of adjudication, court costs, plus time served. You have 6 months to pay court costs. And no return. Don't go back there. All right. Ramon Gonzalez.
He is still a medical loan judge.
Okay. All right. Lloyd Strickland. Hi, good morning to you, Mr. Strickland. You're here on one count of burglary of an unoccupied dwelling unarmed and one count of grand theft, $300 to $5,000. Based on my review of the probable cause affidavit, I do find probable cause. State what's your position on bond priors, failure to appear.
He's being held no bond right now for looks like a failure to appear on a possession of a firearm or ammunition by convicted felon.
Okay.
There's also a pending possession of cocaine, and in 2014, he was convicted of burglary of a structure, possession of burglary tools, and theft. Your Honor, based on his criminal history and his pending charges, and that this allegedly involves someone's home, I'd be requesting a $10,000 bond on count 2.
Okay. All right, Mr. Reedy, anything?
Hold on a no bond capias at this time, so I think he needs to go and resolve that. So I'd ask for a standard bond of $1,000 on count 1 or count 2.
Okay.
There's no standard bond on count 1.
Right.
Well, we're here on counts 2 and 3, I guess.
I mean, on count 2.
I know you meant. All right. What I'll do is this. I'm going to kind of split the baby,
Yeah.
it'll be a $5,000 bond. But realistically, sir, you're going to be held no bond on that other no bond hold. So you're not going to be getting out until you can resolve that. And at that time, you can address bond issues with your division judge. So count two, since it's an ad charge, will be $5,000. Count three is going to be the $1,000. Total bond of $6,000. Good luck to you, sir. All right. Wilson Soto.
Conti.
All right, we have some ad charges here, sir. The first is burglary of an unoccupied structure unarmed. The second is grand theft. The third is criminal mischief, $200 to $1,000. Based on my review of the probable cause affidavit, I find probable cause for counts 10 and 11. For count 12, I find probable cause for I think we said it was a second-degree criminal mischief based on missing amount. State, are you looking to perfect the criminal mischief?
No, Your Honor.
Okay. All right, so I'm going to find PC for second-degree crim mischief. Is he being held on any no bond holds or just other bonds?
Your Honor, on counts 1 through 9, Mr. Soto is county sentenced. He received a 364-day sentence, which would be mitigated to 210 days upon his completion of the SAP and attendance at Narcotics Anonymous meetings. He indicated to me that he will be released on that sentence around the middle of next month, I believe is what Mr. Soto told me. He does work. He is a fence installer. He's had the same job for 5 years. He's indicated to me that that job is still waiting for him when he's released. He's been living in the same residence for the last 2 years, and he believes that his girlfriend will be able to bond him out. I'd ask the court for a $1,000 bond on count 1, ROR on count 3, or $1,000 bond on count 10,
Right.
and an ROR on count 12.
Okay. 12, I'm going to have no requirement for bond, so I'll ROR him on 12. And Mr. Linder, 10 and 11, what's your position?
Your Honor, I'm going to be asking for a $5,000 bond on count 10, a $2,500 bond on count 11. One of the cases that he's sentenced on right now is a grand theft that allegedly occurred, well, not allegedly occurred this year. Noting the alleged dollar amount in count 11 was almost $5,000 in cash.
Okay. All right, anything else, Mr. Reedy?
No, Your Honor.
All right. All right, what I'll do is this. I'm going to, on count 10, I'll give him a bond of $2,500. On count 11, it'll be the bond of $1,000, and then count 12 will be the ROR. So it'll be $3,500 total to bond out on these 10, 11, and 12 charges. Okay? Good luck to you, sir. All right, Thomas Smith.
He's also in Conte, Judge.
Okay. All right, good morning, Mr. Smith. You're here on an ad charge. It looks like there was a KPS felony charge. There's a, oh, hold on, let me see here. It's a possession of a firearm by a convicted felon. So we need to set a bond on that. Just so you know, you also have a status on this case on the 14th, so that would be tomorrow at 9 a.m. What's state's position on bond? And
Your Honor, just to advise the court, it's actually carrying a concealed weapon by a convicted felon. The allegations being when he was located and a show-up identification was conducted and he was searched, law enforcement found an ice pick, which was the alleged weapon. And count 1's an aggravated assault, domestic violence with a $10,000 bond and GPS, where he allegedly threatened the victim with an ice pick and was found with an ice pick concealed in his possession.
Hold on.
Your Honor, I have.
The KPS that I have says felony in possession of a firearm or ammunition.
No, I understand, and that's what under the statute. And if you'd like, I have a copy.
So
of the information.
so that is the heading of the statute,
Exactly,
but within the statute has weapon. So it's just not accurately described in the heading.
Exactly. That's why I printed out if you wanted to see a copy of the information.
You're an officer of the court. I trust you that.
And I've seen it.
Okay.
And I'm going to be asking for a $2,000 bond. He's got he's being held no bond on a court order on a grand theft. He's got, in addition to the $10,000, he's got 1, 2, 3, 4, 5, 6. It looks like $8,000 bonds on other charges
Okay, Mr. Reedy, your position, he's asking for $2,000.
Judge, he has to go in front of Judge Rothschild tomorrow. My main concern was in my reading of the probable cause affidavit, I didn't see anything about carrying a concealed weapon, but I
This
think
is-
Mr. Linder has more information about that.
This is a capias, this isn't a.
Right, but I did look up
probable
I
cause
did look up the probable cause affidavit as to the aggravated assault.
Oh.
And that's why it's an ad charge, because there is nothing in the probable cause affidavit about it. It's in, and I,
Oh,
if
it's
you'd
in
like to
like
see,
a
I printed out a
supplement?
supplement report. When they were searching him, they found concealed on his person an ice pick.
Okay.
Allegedly.
I think it's a matter, Mr. Smith. Mr. Smith and I talked earlier this morning, a couple of times actually. I think he's going to have to resolve this or get this straightened out when he goes in front of Judge Rothschild tomorrow. Right, Mr. Smith?
Yes, but Your Honor, it was.
Hold
Don't
on.
say anything,
Hang on.
Thomas, don't say anything about the facts of your case. Save it for tomorrow because nothing's going to change here this morning. Okay? All right. Good luck to you, man.
All right, so I'll put the $2,000 bond in place, and sir, you can address it with Judge Rothschild tomorrow. Good luck to you. All right, Andrew Casa or Casa? What's that?
Yeah, she was asking the bond.
Oh, sorry. Andrew Casa?
No, Roger,
Oh, okay, thank you. All right, good morning to you, sir. You're here on some ad charges. The first ad charge is a petty theft, third or subsequent offense. And then you have 4 separate violation of probation cases that you're being held no bond on. These are ad charges. Based on my review of the probable cause affidavit, I do find probable cause for the bondable offense, which is the petty theft, and that's a $750 bond. As it relates to the other 4 probation charges, those are going to be no bond holds. You have a hearing before your judge on, I think it's the 3rd of January. Is that correct? Okay, perfect. So January 3rd, you're going to go to court for all of these ad charges. I'm not sure what your other court dates, when those are for the other charges that you've been held on. So good luck to you, okay?
The only question I have is why am I being held with the probation violation if I've already had the same probation violations already?
Well,
You're
here's
on-
the thing. I can't confirm that, but what I can do
What
is,
happened, Your Honor, is
yeah.
these are 94806s. He was arrested originally, given a 94806, so when they attach more charges to him, they're adding
Okay.
94806s.
All right. I understand. So what happened is that because you're on probation on 4 separate cases and they added a new charge, the petty theft charge, that automatically generates a new violation of probation on the other ones. It's not a new case. It's just adding to your probation violation one more additional allegation of a new offense. Okay?
So I have 2 violations basically.
Well, I'm not sure what you came in on before, but whatever came in before, yes, and then they added a new law violation.
So 1 new charge, right?
Yes. Okay. All right. Good luck to you. You'll go see your judge on the 3rd. All right. Alexon Alcindor. All right. Good morning to you, sir. You're here on 1 count of possession of PVP, 1 count of false identification given to a law enforcement officer, and you also have a misdemeanor capias. It looks like a traffic offense. Based on my review of the probable cause affidavit, I do find probable cause. Let's see here. So you have a bond on the misdemeanor charge. That's an operating without a valid license. And that was based on a capias. You have a $250 bond on that. As it relates to the other 2 charges, it's a $1,000 bond count 1 and no requirement for bond on count 2. Does anyone want to speak to that? Or
Judge, yes, in reference to count 1, I understand your hands are kind of tied on count 3. But in reference to count 1, we'd be asking you to consider releasing Mr. Alcindor on pretrial release. He's been here his whole life. He's not working. He gets disability. He does have some mental health issues. His mom is his legal caretaker. He's currently living in Fort Lauderdale. Judge, from what he understands, his mom's also going through her own health issues. So financially, she's not in a position to post his bond. We'd be asking you to consider releasing him on count 1 on pretrial, and maybe his sister can come up with the bond on count 3, Judge.
okay.
Your Honor, I checked. Mr. Alcinder's had multiple failures to appear in the past. At least once he was picked up on a warrant for violating pretrial on another case.
I don't know that pretrial is necessarily, it might put him in a situation where it creates more problems. What I can do is on count 1, I'll give him a bond of $500. Count 2, I'll leave it at 0 requirement, and on count 3, he has the 250. That's $750. Hopefully, he can bond out. If not, or even if he does bond out, he does have a hearing before his judge on the 18th. So make sure you go back to court on the 18th, even if you bond out. Okay? And I'm signing also. It looks like a photograph order for.
Not for him, though, Judge.
Oh, okay. Well, a couple for other people. That's fine. Those are all granted. All right, so good luck to you, sir. It's a total of $750 in bond. All right, Bobby Tucker.
Mr. Tucker's a person, page 11.
All right, good morning, Mr. Tucker. You're here on 1 count of petty theft, third or subsequent offense. Based on my review of the probable cause affidavit, I do find probable cause. The bond's currently at $750. Does anyone want to speak to that?
I'm just asking that the standard bond be kept in place.
Okay, can he bond?
Judge, from what he's telling me, there's no one out there to help post his monetary bond. He's a real estate agent. He's been doing that for about 20 years. However, right now, he's taking care of his parents. They are both bedridden. They're the only people that could access any of his funds in order to post bonds, but because of their medical situation, because they're bedridden, there's no way they can bond him out, Judge. So he's asking, Your Honor, he lives in Deerfield, been residing in the same apartment for 8 years. He's asking, Your Honor, if you would release him on pretrial release. He'll come to all of his court dates.
I don't believe he's a good candidate for pretrial. He already has a theft from about 7 months ago, felony theft last year, theft 2015, theft 2014, 2 prior failures to appear out of the state of Georgia. Let's see, DUI 03, another DUI 01, theft 2000. Yeah.
All right, I'm going to leave the bond at $750. Good luck to you, sir. All right, and David Zugaj.
Mr. Zuka is here at Main Judge.
All right. Good morning to you, sir. You're here on 1 count of possession of PVP, 1 count of possession of drug paraphernalia, and 1 count of obstruction of highway. Based on my review of the probable cause affidavit, I find probable cause for counts 1 and 2. On count 3, it's a panhandling, but they don't say he actually obstructed, although I can imagine how that could obstruct. They don't actually say that. So I'm not going to find probable cause on count 3. I'll ROR him on count 3 unless, State, are you looking to perfect?
One moment.
Sure.
I mean, it's really, Your Honor, you can continue.
All right. Okay, so as it relates to counts 1 and 2, I'll set bond. Mr. Romero, anything on that?
Judge, he's been here since 1998. He's 35 years old. He's homeless, financially indigent. Judge, this is a nonviolent offense. We'd be asking you to consider an ROR.
And
he had an obstructing traffic last month in June. Last year, trespass 2016, possession of PVP 2015. I just want to check to see. Could you please? Scroll up to Florida summary. Showing 4 prior failures to appear.
all right, I'm not going to ROR him. I'll reduce the bond on count 1 to $500. No requirement for bond on count 2. ROR on count 3. So $500 total bond. Good luck to you, sir. All right, Calvin Frazier.
Mr. Frazier's here, Main Judge.
All right, Mr. Frazier, you are here on 1 count of petty theft, 100 to 300, 1 count of fraud, uttering a false instrument. Based on my review of the probable cause affidavit, I do find probable cause. Anything on bond? Can he bond out?
Judge, no. From what he advised me is normally his mother would be in position to bond him out. Unfortunately, his mother's sister just passed away. So with the funeral expenses, basically this time they have no other money because they spent everything on the funeral expenses. He lives in Pompano Beach with his mom, been residing at the same location for about 1 year. He is working. He works in concrete. He just got employed. He's been working there for about 1 month, making about $12 an hour. From what he advised me, he's been living in our community his whole life, Judge. So he's asking you to consider releasing him on pretrial release.
Does he have prior failure to appears or prior?
And
just so the court knows, when he was contacted for the pretrial interview, he
Yeah.
did sign the booking report refusing the interview.
Oh, Well,
Yeah, and it wouldn't appear that he's lived in our community his entire life. I'm checking his driving record. In '09, his listed residence was in Citrus County. He resided in Palm Beach. Matter of fact, in Citrus County in the past, this was in 2011, he was convicted of obtaining goods and services by fraud. 1, 2, 3 counts, worthless check, 1, 2, 3, 4, 5, 6 counts. Grand theft auto in the past with the fleeing and eluding, the failure to appears that were mentioned by pretrial.
okay, well, he refused pretrial, and it doesn't sound like he's necessarily being upfront with the public defender either. So I'm going to leave the bond at $1,000 on count 2. I'll have no bond requirement on count 1, so it'll be a total bond of $1,000. Good luck. All right, Anthony Burnett.
Mr. President, Judge?
Hi, good morning. You're here on 3 probation violation cases that are no bond holds. You also have a KPS, a misdemeanor offense that has a bond of $1,501, but you are being held no bond on the violation of probation cases. So you're going to see your judge on the 15th. So that's what, Friday? So you'll go Friday at 8:45 a.m. Good luck. Angel Ruiz Rodriguez.
He's here.
Hi, good morning. You're here for a violation of parole, so I have nothing to do with that. You're going to have to go before the Department of Corrections on that issue. It's a no bond hold, so they'll come and figure out what they're doing as far as the parole case. All right, good luck.
Thank you very much, ma'am.
Yep, have a nice day. Robert Espinosa.
He's here, ma'am.
Hi, good morning to you. You're here on 1 count of violation of community control. It's a no bond hold. You're going to see your judge on the 18th at 9 o'clock.
Next Monday, huh?
Yeah, Monday. All right, bye-bye.
Thank you, Doc.
All right, Jonas Rittenhouse.
Mr. Rittenhouse is here. Oh, you just went to the restroom?
Okay.
Oh, wait. Mr. Rittenhouse, come on up. He's approaching, Judge.
Thank you. All right, good morning, Mr. Rittenhouse. You're here on 1 count of grand theft, $300 to $5,000, and 1 count of possession of cocaine. Based on my review of the probable cause affidavit, I do find probable cause. Can you bond out? Is this a pretrial case?
Judge, Mr. Rittenhouse is going to be asking Your Honor to sign a phone order. He believes he can then contact his uncle to post his bond.
Okay, I'll happy to sign that. I'll leave the bonds at $2,000 if he thinks that can be posted. Okay, all right, so $2,000, $1,000 count 1, $1,000 count 2. Good luck to you, and I'll sign a phone order for you. All right, Christopher Klingon. Hi, good morning. You're here on 1 count of grand theft, $300 to $5,000, 1 count of violation of probation or community control. It looks like 2 counts of that. So you have an ROR on one of those violation of probation counts. You do have a no bond hold on the other. And then the grand theft, I do find probable cause for that count. It's a $1,000 bond. You're going to see your judge on the 19th at 8:30 a.m. Bye now. All right, Ludwig Prophet or Profete?
Mr. Prophet is here approaching, Judge. He's going to be hiring his own private counsel.
Understood. Okay. Good morning, sir. You're here. Possession, 1 count of possession of cannabis over 20 grams. Based on my review of the probable cause affidavit, I do find probable cause. Can you make a $1,000 bond?
Yeah.
Yeah. Okay. All right. So I'll leave the bond at $1,000. Good luck. All right, Dominic Ben Civengo.
He's here, President Judge Amin.
Hi, you're here on 1 count of grand theft, $300 to $5,000, and fraud, uttering a false instrument. Based on my review of the probable cause affidavit, I do find probable cause. Can you make a $2,000 bond, or what's his situation?
He's asking Your Honor to consider releasing him on standard pretrial. He's 27 years old. He's been residing in South Florida for about 2 years now. Unfortunately, right now he's homeless. He's trying to get clean. He already spoke, I believe, last week with a representative from Primary Purpose. He was scheduled to actually check in today and reside there. From what he informed me is one of the conditions, I guess, you have to pay your way. It's $175 per week. He is working at a job of paving, which would allow him to pay for that rent. So, Judge, he's asking if Your Honor consider releasing him on standard pretrial on counts 1 and 2.
Okay, Mr. Linder.
I'm going the complete opposite direction. I'm asking for a bond increase on count 1 to $5,000. First off, 2016 out of Palm Beach, burglary of an occupied dwelling, possession of cocaine, grand theft auto, trafficking in stolen property. sentenced to a year and 5 months state prison. He was released May 30th of this year. I am showing 3 separate warrants out of the state of New Jersey.
Active?
Yes, all for thefts.
And one actually does say, will extradite from Florida.
So,
Well, Mr. Romero?
Judge, I understand, but right now he's financially indigent. He's gonna, while this matter is in the process of being litigated, while the state decides whether or not to file these charges,
Bless you.
at least he can get help for some of his issues, and he believes he can receive that help at primary purpose. He'll still be under standard pretrial. He'll still have to report and everything like that. So that's what we'd be asking for, Judge.
Your Honor, his indigency is just but one factor. All of what he's here for and his priors involve taking other people's property. He poses a risk to the property of the community. He's wanted in another state on multiple like offenses for not showing up in court.
Yeah, he's definitely not going to be released at pretrial. I'm going to grant state's request for bond in the amount of $5,000 on count 1. Count 2 will be $1,000. Sounds like they might be attaching some holds to him anyway, so I'm not sure what's going to happen with that, but it's going to be a total bond of $6,000. Good luck to you, sir, and clear up whatever you need to clear up in, I think it was New Jersey as well. All right, Donson Jimenez?
I believe North Broward, Judge.
Okay.
Your Honor, he's in a wheelchair. Give me 1 second, please.
Okay, no problem.
Here he is.
Hi, good morning to you, sir. You're here on 1 count of grand theft, $300 to $5,000. You also have 3 separate violations of probation or community control. Are those out of county?
Yeah, they're out of Dade.
Okay, out of Dade County. So you have a $1,000 bond on count 1, and I do find probable cause based on my review of the probable cause affidavit for that. You have no bond holds for Miami-Dade County probation or community control cases. It looks like there's 3 separate cases on that. So you're going to be held no bond. If you can bond out on the Broward case, then they'll potentially take you down to Miami. I guess Miami will make that decision. But otherwise, you'll be in no bond until you resolve your case here in Broward. So you'll have to figure out what you want to do with that, okay? All right, good luck to you.
Thank you.
All right, Jose Hernandez?
He's here present, Judge?
Okay, good morning, Mr. Hernandez. You're here on 1 count of grand theft, $300 to $5,000, 1 count of resisting or obstructing an officer without violence, 1 count of resisting a loss prevention officer, and you also have a violation of probation, it looks like, from another county, which is a no bond hold, and that is out of Madison County. So Madison County probation violation, no bond. The other 3 I do find probable cause based on my review of the probable cause affidavit. You're also in a situation where you're going to have Broward holds. Those are bondable, and then you're going to have to go and figure out what's going on in the other county. The other county will choose if they want to pick you up if you get the Broward holds released. Anything on bond for the Broward cases?
Judge, the only thing I'm going to be asking is if you would enter an order allowing us to photograph Mr. Hernandez's injuries.
Granted. All right, so I'll leave the bond at $1,000 count 1, no requirement for bond on counts 2 and 3, and he's no bond on the other probation hold. Okay, Ainsworth Gordon.
Mr. Gordon is approaching. Good morning.
Good morning. Good morning, Mr. Gordon. You're here for pursuant to arrest warrants, and you have 1 count of interference with the custody of a minor or incompetent person, and count 2 is burglary of an occupied dwelling unarmed. Again, these are from warrants, so there has already been a probable cause determination. Let's talk about bond.
Yes, Your Honor, and I understand Judge Rothschild put a $5,000 bond on count 1. That being said, I am going to be asking for bonds on counts 1 and 2 at $50,000. An order of no victim contact, no contact with the minor child, and no contact with, 1 moment, Your Honor, Jasmine Clark, and additionally no contact with Humroy Williams. Additional condition I'm going to be requesting is that Mr. Gordon surrender his passport prior to his release from custody. Your Honor, the allegations in the affidavit speak for themselves. There are a number of alarming allegations in this affidavit. not just the actual, the allegations that support the elements of the offense, but noting one, that, and I believe the evidence is strong in that this was a conversation he had with law enforcement, that he used the child and returning the child to the mother in a way to try to avoid any facing any consequences for this. Basically saying, not basically saying, he'll return the child if the mother of the child agrees not to press charges against him. Also noting, it's as stated, he told them he would bring the child back to Plantation. He was arrested in Volusia County that night. He was brought down here from Volusia County. It does not appear he had any intention of bringing the child back. Your Honor also noted, and I would submit it's relevant, it is in the affidavit, so it is for the court's consideration. There's an allegation that he threatened Ms. Clark's husband with a firearm at his place of work. I can inform the court, I spoke with Detective Shout, who authored the probable cause affidavit. That matter was and is being investigated by Broward Sheriff's Office, and they prepared a not in custody probable cause affidavit, obviously, because they weren't able to effectuate an arrest at the time, since Mr. Gordon, according to the allegations, was traveling with the child en route to Volusia County. Your Honor, at this point in time, especially considering he doesn't have ties to the community, I've got concerns for the child's mother, her husband, and I think there has to be concern about him trying to do this again and not getting caught.
Okay. Mr. Reedy or Mr. Romero, do you want to respond?
Judge, in speaking to Mr. Gordon, he's been residing in the state of Florida for about 10 years now. He's 34 years old. He is a U.S. citizen. From what he informed me, he doesn't even have a passport.
Okay.
Having said that, Judge, he does have ties to the community. He is a business owner. He does have a Jamaican restaurant, which he manages. He has employees. Unfortunately, business is slow. So from what he told me, at the end of the day, after he finishes paying off his employees, his payment is approximately $250 per week. He travels back and forth. He lives in Volusia County, and he also lives here in Broward County. In Volusia County, Judge, my understanding is he retained private counsel up there, and right now this dependency matter, there is an open dependency matter looking into as far as custody of the child.
A
Judge,
dependency matter or a custody issue?
Custody issue, Judge.
Okay.
Judge, my understanding is he lives in the land. He's been residing there in the same location for over 5 years. He lives there with his fiance. From what he tells me, there's no way he's going to be able to afford to pay the $50,000 bond, which the state is suggesting. I believe his prior history is quite minimal, Judge. We'd be asking you to leave the standard bond in place, leave the bond in place, which was set at $5,000 on count 1. And on count 2, we'd be asking you to consider setting a $5,000 bond as well, for a total of $10,000.
Okay. Any last comments from anyone?
Yeah, Your Honor, and I also would just note he's been arrested. He's had, in 2009, he was arrested in Volusia County for failure to appear in court. He did have a prior unauthorized sale of video, carrying concealed weapon, and misdemeanor possession of marijuana in 2009 in Volusia County. They were withholds. Possession of cannabis 2006 in Volusia County with a withhold. He was convicted of giving a false name or ID to law enforcement in 2005 in Volusia County.
All right, anything else, Mr. Romero? Sorry.
No, it was just that went to my point as far as minimal contact with the criminal justice system. And I believe from what I heard, they were like misdemeanor offenses.
And, Your Honor, I'm sorry. The only other thing I would ask the court to do is if the information that Mr. Romero has is that Mr. Gordon doesn't have a passport, what is customary is then I would ask that Mr. Gordon be placed under oath to testify that he does not have a passport because obviously then one can't be surrendered. I wouldn't obviously ask for one to be surrendered, but there needs to be something in place that it's not just Mr. Romero representing that he doesn't have one.
Okay. All right. I saw him raise his right hand. Is he willing to do that?
Yes, ma'am.
All right. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay. All right. Do you have a passport?
I do not have a passport, ma'am.
All right. Do you have any active applications for a passport?
No, ma'am. The only thing I have is my U.S. citizenship certification, not naturalized citizenship. That's the only thing I have in my position as far as that.
Okay. Any other questions on just that issue?
No. I just asked that then in that case, an additional release condition be that he may not apply for a passport during pendency of the case.
All right. Okay. What I'm going to do is this. On count 1, I'm going to give him a bond of $20,000. On count 2, I'm going to give him a bond of $5,000. It's going to be a total bond of $25,000. There is going to be a requirement that he not apply for a passport during the time that he's out on release. Also, if he's able to be released, I am going to put him on pretrial with a GPS monitor. I understand he goes back and forth. I'm not sure how that works as far as he can't go back and forth. Do you have, I know you have a business here. Can you speak with Mr. Romero and verify if you have an address that you can stay here full-time while the pendency of this case is ongoing?
Judge, what he was explaining, he really has no location here to live in Broward County. He goes back and forth. He's living in DeLand, and at DeLand is where he resides there with his fiance. He has no place to live right now. By imposing a pretrial, that's basically going to force him to find an apartment here in Broward County to reside. I don't think there's ever been any issues as far as him trying to flee the area or Judge.
Frankly, Your Honor, that's why I was asking for a higher bond, because the only information I had was that he resided in DeLand, which I know at GPS they would not be able to apply, and so there would be no way to monitor him, and he could travel freely at all times. And my concern is this happening again.
All right. I misunderstood that because I thought that he also had a business here. I knew he had the business in DeLand, but I thought he also had a business here.
I thought he said he resides in both. I thought that's what
and
he
I
said.
thought he had, so I thought he was just going back and forth. That was my understanding. But if he's only living in DeLand and he's not living here, then that's a different consideration. Can we clarify that?
Let me inquire, Judge.
Okay.
The way the court interpreted it was what
Okay.
I understood as well.
All right. Well, I don't know that this is going to be an option.
Okay, Judge, my understanding, I believe there was some sort of misunderstanding. He clarified it. His restaurant is actually in DeLand, Florida.
Okay.
He has a second business. He does home delivery. It's called A&G Fashion. So basically, he has clients that are here in Broward County. He comes here on a bi-weekly basis, and whenever he comes down here, he stays in a motel.
Okay.
In order to serve his clients.
All right. What I'm going to do is this. I'm going to give him a bond of $20,000 on count 1, and it's going to be $10,000 on count 2. A total bond of $30,000. Wait, what did I have before?
20 on 1, 5 on 2.
I had a total of 25 before. Is that correct?
Yes.
Okay. Based on this new information, the fact that he really doesn't have a residence or a business, or I guess a business location here in Broward County, I'm going to change the bond on count 2. It's going to be a $10,000 bond on count 2, $20,000 bond on count 1. Total bond of $30,000. I obviously can't put any pretrial restrictions as far as pretrial release, GPS monitor, that type of thing on him, which would have given me a bit more of assurance that he would be able to be monitored and make sure that he gets here back to court. But it's going to be $30,000. There's going to be no victim contact, so no contact with the minor. Also, no contact with the other people that were involved in this case. So, no victim and witness contact. Obviously, if he hires an attorney or has a public defender, they can reach out and investigate as it relates to the witnesses, things of that nature, but he cannot himself. All right, $30,000, no victim contact, no witness contact. Good luck to you. All right, Terry Jewell.
Judge, I've been informed he bonded.
Okay. All right. Ali Maximus, or Ali?
He's here present, Judge, I mean.
Okay, good morning to you, sir. You're here on several counts, so just bear with me. The first is possession with intent to sell, manufacture, deliver alprazolam within 100 feet of a convenience business. The second is trafficking in oxycodone, 14 grams to 15 grams. Trafficking in cocaine, 28 grams to 200 grams. Possession with intent to sell, manufacture, deliver hydrocodone within 1,000 feet of a special area. Possession with intent to sell, manufacture, or deliver PVP within 1,000 feet of the convenience business. Trafficking in heroin, 4 to 14 grams. Possession with intent to sell, manufacture, or deliver cannabis within 1,000 feet of a convenience business. Possession of a controlled substance without a prescription. Possession of a weapon or ammunition by a convicted felon. Based upon my review of the probable cause affidavit, I do find probable cause for the offenses. I'd like to hear from both sides regarding bond.
Your Honor, the state's going to be requesting that the standard bonds be kept in place based not only on the minimum mandatory sentences he faces if convicted on the trafficking charges, but also his criminal history, which includes 2014 delivery of cocaine, 30 months in Florida State Prison. He was released September of last year. Possession of cocaine, and he was classified as a habitual offender in that matter. 2014 possession of cocaine, 27 months in Florida State Prison. 2011 delivery of cocaine. 2003 burglary of a conveyance, 1 count of battery, violation of probation, 13 months Florida State Prison. And Your Honor, I would also note as an aggravating factor, I won't go into specifics, but it does mention in the probable cause affidavit, and I was able to confirm this through the Florida Department of Law Enforcement, that Mr. Maximes is a registered gang member.
Okay. Defense, your position on bond?
Yes, Judge. In speaking to Mr. Maxims, he's been residing in Florida his whole life. He's 32 years old. He's currently employed. He works in mobile detailing. He's been doing that for about 10 years. He makes approximately about $100 a day doing that. He lives with his fiance and newborn child. His newborn child was born December 6th. His fiance had a C-section, so right now she's not in any condition to work. They live in an apartment in Pompano Beach. They've been renting there for the past 2 years now, and their monthly rent is about $1,000 per month. From what he informed me, his fiance is the only person that can post his bond, but she can't come anywhere close to what the bond is currently set at. If you indulge me for about 10 more seconds, I'm going to inquire Mr. Maxim how much does he think his fiance can afford.
Okay, and also, Mr. Linder, I need a recommendation for bond on count 9.
Yeah, Your Honor, I'd be recommending a $2,500 bond on count 9.
Okay.
Your Honor, well, I'll wait till Mr. Romero's done.
Okay. And when was he released from prison last?
September of last year.
Okay.
Judge, he believes the only thing his fiance can come up with is $700. So he's requesting a total bond of $700.
Your Honor,
Okay, yes.
just based on the amount of drugs that were found in this home, the representation about the resources he has access to really, I don't find to be very credible.
Okay. What I'm going to do is this. I'm going to leave the bonds in place and require that if he is able to bond out, that there be a nebia proffer to the court approved by a judge. Certainly he can go before his division judge and ask them to consider other factors when they make that showing, or at least some sort of showing of ability to post a bond. But at this point in time, I'm going to leave the bonds as they are. I'll grant the state's request for a $2,500 bond on count 9. So it's going to be bonds in the amount of $5,000 count 1, $250,000 count 2, $15,000 count 3, $7,500 count 4, $5,000 count 5, $75,000 count 6, $5,000 count 7, $1,000 count 8, and again, it's the $2,500 for count 9. So you can add up all of that to total bond plus a nebia requirement if he is able to post bond.
And Your Honor, we would ask, in addition to nebia, that full collateralization be required also as part of the nebia.
Okay, nebia plus full collateralization.
I will prepare an order for the court.
Okay.
Judge, Mr. Maxine's wishes to address your point. I advise him not to talk about the facts of the case.
All right, sir, hold on. I'll give you a chance to speak. You just give me 1 second. I need you to raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, before you say anything else, you can put your hand down, but do you understand that everything that you say is being recorded and they can use it against you? So if you say anything about the facts of the case or anything else that could implicate you, the state attorney's office can pull this video and can use this video as evidence against you. Do you understand that?
Yes, ma'am.
And you understand that the public defender, Mr. Romero, has advised you probably shouldn't say anything on the record. Do you understand that?
Yes, ma'am.
With that being said, do you still want to say something?
Yes, ma'am, I do, ma'am.
Okay, go ahead.
I just want to let you know, ma'am, I want you to have a little lenient on me, ma'am, please, because I just had a child on the 6th. She just had a C-section. She's alone. If anything happens, I go to court. They keep me, ma'am. That's cool, whatever, ma'am. But I didn't, ma'am, I will just have a little lenient on me. Let me just go back to my family just for a couple of days. Let me get things situated, ma'am, please.
Well, here's the thing. I'm not going to grant you the leniency that you're requesting. This doesn't prevent you from asking your division judge. If you have a public defender or a private attorney that's going to assist you, you can talk to them and they can come to your division judge and provide your division judge with some information regarding truly how much you can post and where that money would be coming from. But as far as this morning, based upon what I've heard and the allegations in the probable cause affidavit, plus the fact that you were recently released, well, about a year ago were released from prison, you know, some of the comments were that you've been living in this community for X amount of time. Some of that time has been in prison. So that's something that the court has to consider as far as danger to the community. And based upon the nature of the amount of drugs and different types of drugs that were found, I do feel that these bonds are appropriate for the time being. But you can address it with your division judge, okay? Good luck to you. All right, Torrance Wilkins. All right, good morning. You're here on one count of violation of probation. It's going to be a no bond felony hold. You're going to see your judge on the 18th at 8:30, so you'll go to court on Monday. All right, good luck. I have Alex Blake.
Mr. Blake, come on up, please. He's approaching.
Sure. All right, good morning, sir. You're here on two separate cases. One count is fleeing, aggravated fleeing and eluding, and the second count is burglary of an unoccupied dwelling unarmed. There's already been probable cause that was found based upon, it looks like, I have a hold for Collier County.
Your Honor, he was just brought down here for Collier County,
Okay.
I imagine, for his arraignment. He's being held in Collier County on charges of carjacking with a firearm or weapon and fleeing and eluding law enforcement. Considering that, Your Honor, the state would be requesting a $5,000 bond on count 1, a $10,000 bond on count 2.
Okay, Mr. Romero?
Judge, if I heard correctly, he currently has a Collier County hold on him?
For carjacking and fleeing and eluding, is that correct?
I'm sorry?
The other hold?
Yeah, it's also for fleeing and eluding in Collier County and a carjacking.
Yeah, Collier County.
Okay. Judge, unfortunately, from what he advised me, he's not working. He lives with his cousin. His cousin's a nail technician. She's the only person that's going to be able to post his bond, but if she posts his bond, then obviously he'll be transported to Collier County. So I'd ask you to take that into consideration when determining a reasonable bond on counts 1 and 2.
Well, what do you think is a reasonable bond on counts 1 and 2?
$1,000 each.
Okay. All right. What I'll do is this. I'm going to give him a $5,000 bond on count 1. I'll give him a $5,000 bond on count 2. It's a total bond of $10,000. Obviously, he has the other hold for those other cases in Collier County, so he can figure out what he wants to do as far as bonding and or resolving it here. Good luck.
Your Honor?
Yes.
Just to advise the court, I just received, in whatever the court wants to do, I just received a text from Mitch Polay that he was contacted by Mr. Maxime's family about a half hour ago. He was wanting to inquire if Your Honor would recall his case to be reheard.
I mean, which case is that?
That was the last case, the trafficking. The very last
trafficking.
case. Yeah.
Is he coming down, Mr. Polay?
He's asking if it could be, I guess he's asking if it could be reset to 1:30.
I mean, he can come back at 1:30. You know, I mean,
I'm just relaying.
I can understand. I mean, I'll put it on the docket at 1:30, and we can address at that time whether I will consider changing the bonds or doing something else. Obviously, we had quite a conversation as it
Yes.
relates to his case and the charges, but I don't have a problem with Mr. Pole coming in at 1:30 and asking me to readdress, and you can make arguments as it relates to
Sure.
whether that's appropriate.
Sure.
Okay? All right, so if we can put that, give me 1 sec.
Just wanted to let the defendant know, even if he posts bond, he will not be released to Collier County. He was court ordered to go before a judge in Clark County for his arraignment.
Yeah.
Okay. Okay, before they transport.
Yeah.
Okay.
After
All right.
the 18th.
Thank you, ma'am. All right, William Feeman or Feynman?
Just to clarify, we are
Mr. Freeman, come on up.
Yeah, so Mr. Maxime will come back in the afternoon at 1:30, and we will address whether I will address it.
And what I would just ask, Your Honor, just to be safe, if it's okay that I wait till 1:30 to have you sign the Nebbia
Yeah.
hold, if you could just order on the record that the jail is not to accept any bond between now and then.
Yes, so the jail is ordered not to accept any bond on, give me his full name,
Ali Maximes?
on Ali Maxime's.
the court would also direct them to bring him back at 1.
Yes, that we've already taken care of. But as far as, yeah, so no bond may be posted on Mr. Maxime between now and 1:30.
Thank you.
Or now and when we address his case.
Of course. Thank you, Judge.
At the 1:30 docket. Okay, sorry about that, Mr. Feeman. You're here on 1 count of violation of probation. It's a no bond hold. You go see your judge on Tuesday, which is the 19th at 8:30 a.m. Okay? Good luck. All right, Rayshawn Walker.
Mr. Walker, come on up, please. Page 19.
Good morning, Mr. Walker. You're here on 1 count of possession of cannabis, 20 grams or less. You also have a violation of probation case that has a no bond hold. Based on my review of the probable cause affidavit, I do find probable cause for the cannabis, which is a $100 bond. You have a no bond hold, though, on your probation case, which you'll go to court on Monday, the 18th at 8:45 a.m. Okay? All right, bye-bye. Juan Moran or Moran?
I believe North Broward, Judge.
North Broward, Your Honor.
Okay. Hi. Say it again? Moran. Okay, Mr. Moran, you're here on 1 count of possession of heroin, 1 count of possession of drug paraphernalia. You have a violation of probation, it looks like, from another county. You also have a couple tickets that are not for magistrate here. The other county probation violation is a no bond hold, so that's going to hold you in indefinitely. As far as the possession of heroin and drug paraphernalia, based on my review of the probable cause affidavit, I do find probable cause. As far as bond on this, let me see. And just so you know, it looks like it was Palm Beach County that the probation, you were on probation for opium, delivery, sale, and manufacture. Okay. As far as it relates to the possession of heroin, drug paraphernalia, does anyone want to speak to bond on that?
Nothing from the state.
No, Judge.
Okay, so I'm going to leave the bond at $1,000 on count 1. No requirement for bond on count 2. Again, you have the no bond hold for Palm Beach. So what you can do is you can either resolve your case here in Broward through whether it be trial, whether it be a motion, whether it be a plea, whatever it may be first, and then go to Palm Beach, or you can post a bond on the Broward case. It's a $1,000 bond, and then Palm Beach will come and get you, and you can deal with your probation violation. So you just have to choose what order you want to do that in, okay?
All right, thank you.
All right, good luck. Okay, Jaral, Caesar Nation?
Mr.
Or Nation?
Judge at me.
Okay.
Could you pull?
Hi, good morning, sir. You're here for 1 count of robbery with a weapon. Based on my review of the probable cause affidavit, I do find probable cause. State, what's your position on bond?
Your Honor, 1 moment. I just need to check, verify a prior.
Okay.
2011. Your Honor, in 2011, Mr. Caesar Nation was arrested for and pled out carjacking with a firearm or deadly weapon and robbery with a firearm or deadly weapon.
What year was that?
2011.
What did he receive? Did he go to prison for that?
1 moment. No, he did not. 1 moment. Looks like he was given withholds on both counts. Regardless of that, though, Your Honor, based on a plea to those type of charges and the allegations in this case, the state would be seeking a $50,000 bond.
Okay. Defense, your position on bond?
Judge, my understanding is, yes, he does have that prior back in 2011, so it's over 5 years. He did receive a withhold. He was placed on probation. He was placed on a combination probation. First community control for 20 months and then probation. Judge, he's shown he could be supervised. He wasn't ever revoked on that case. Judge, he's a single father. He has a 2-year-old. Right now he's been residing here in Florida for about 25 years. He does roofing for a living. He just started that. He's making about $13 per hour. He lives with his mother in Pompano Beach. His mother's been residing at that location for about 10 years now. Their monthly rent is about $700, in which he shares the expenses with her. His mother is a caretaker. And Judge, like I said, he's a single father. He's the primary residential parent. So the child stays with him during the week. On weekends, the child stays with the mother. Judge, we'd be asking you to consider setting somewhere in the neighborhood of $5,000 on count one. I believe that's something that his mom may be able to afford, Judge.
Okay. Did you want to say anything
Well, I
else?
just think on a first-degree felony, and I would also note, which is a factor for the court to consider, the evidence against him, and that there's DNA evidence that was left behind at the scene. I don't believe a $5,000 bond would be appropriate.
And I would point out, Judge, that even though this charge is robbery with a weapon, the probable cause affidavit indicates something that appeared to be a yellow hammer was used. We don't even know what this weapon allegedly was. What we do know is that it was never brandished at the patrons. The patrons were never threatened by it. The employees were never threatened with a weapon. I think this is barely robbery with a weapon. I think it's more of a robbery without a weapon.
Well, I don't know about that. I mean, I agree that it doesn't say that there was any brandishing or any, there's no allegation that they put the alleged weapon towards anyone. However, there were people within the proximity of I think it was a pawn shop, and there was a display case that was smashed into in front of everyone.
And, Your Honor, I would also note, because it does mention...
That's the allegation,
There were customers and employees that were in fear for their life. Someone breaks out, and it's described as a hammer, and it's certainly an item that, with enough force, can smash a display case. It would make sense that no one might want to confront this person because he's carrying that item that could be used against them.
All right, what I'm going to do is this. I'm going to put a bond in place of $35,000. I'm also going to require pretrial release with a GPS monitor if he's able to bond out. Good luck, sir.
Judge, would you waive the cost supervision on the GPS as far as the $5 per day?
Yeah, I'll waive that.
Is the defendant permitted to work if he is employed?
Level 2?
No, not at this time.
Thank you
Not
so
at this
much.
time. He can ask his division judge if he's able to find employment and they're willing to accept the terms of his release. As it relates to that, I'll let him work, but otherwise, no. Okay, I have...
Judge,
Yeah.
right now, like, he is a single father, so right now he's the financial provider of his 2-year-old. He works starting at 6:45 in the morning. A level 2 with the monitor will still allow him to go just to and from work. That's all he's going to do. If he deviates at all, then there's going to be a warrant submitted for his arrest. I'd ask you, considering, as far as the prior that we referred to, he was given a withhold. He did community control. I know allegations here are alarming, but the $35,000 plus pre-draw on GPS, I believe that's reasonable as far as with the level 2 monitor.
Again, I don't feel comfortable with that. I say that because we do know that there is a prior. Whatever happened in that case, we don't know the facts, but we know that he either went to trial or, well, I guess he didn't go to trial if it was a withhold. It was a plea on a carjacking and I forget the other charge.
Robbery.
And a robbery. And then even if he successfully completed all of probation, community control, whatever it may have been, we're back in a situation where we have this type of allegation, and that's very concerning to, the danger to the community. So at this point in time, I will not permit that. Again, he's free to go before his division judge and ask the division judge to change this. Maybe at that time, they can give him or her, whoever the division judge is, more information that might make that judge feel more comfortable, but not at this point. Good luck. Okay, oh, I'm sorry. Wrong one. Sorry. Okay, I have Joshua Avelinet.
He's here, President Judge Amin.
All right, good morning to you, sir. You're here for 1 count of possession of buprenorphine. Based on my review of the probable cause affidavit, I do find probable cause. Is he a candidate for pretrial or no?
It's a self-propelled ballistic knife. It's like you hit a button. And
Okay.
And, Your Honor, I can tell you he's been classified as a habitual offender. He's got 5 prior failures to appear. 2012 out of Palm Beach County, possession of a ballistic self-propelled knife. Arrested in 2012 Palm Beach, failure to appear. Sorry. Attempted burglary of a structure, criminal mischief. And when he was arrested on that, he had an active warrant for failure to appear, and that was in 07. Another failure to appear, 01.
All right, I'm not gonna put him on pretrial, and it looks like he lives in Boca Raton anyways, so I'm not sure how they supervise out of county, but as far as any sort of monitor or anything, I'll leave the bond at $1,000. Okay. What's that?
Would you sign a phone order?
Yes, that's granted. Okay. Nick Ware, Florosier.
I've been informed you bonded.
Thank you. Michael Smith.
He's approaching.
Hi, good morning to you, sir. You're here on 3 separate cases of violation of community control. They're all no bond holds. You're going to go before your judge, it looks like on the 2nd of January. So you'll have a no bond hold until then. Good luck to you. All right, Jihad Asaf.
That guy from yesterday.
Mr. Asaf. Judge, he declined the service of public defense.
Thank you. All right, so you're here on 1 count of violation of probation. It's a no bond hold. You're going to go before your judge on the 2nd of January at 9 a.m. Good luck. All right, Jeremy Buenvicino.
Medical reset.
Okay.
Your Honor, the only thing I'm going to ask, because it seems now he's been reset from starting in the weekend through today, I'm just going to ask if the court can make a probable cause determination, which you are permitted to under the rules of procedure. He need not be present. I have no problem with him being brought back for bond purposes when he is able to, assuming the court finds probable cause.
Okay, Mr. Reedy, your response, if any? Okay, so based on my review of the probable cause affidavit, I do find probable cause. I've reviewed this every day, I think, since I've been here, since he's been on the docket. So that would be, I guess, counts 1, 2, 3, and 5, and then the other 2 are the probation violations. So I'll check off the box that the court has found probable cause, and then as it relates to bond, what, you just want to keep resetting him?
I'm fine with that. Yeah.
Okay, all right, so he'll be reset for bond purposes only. Now, I checked off the box here. Should I sign this as well? What would you like me to do with this paperwork? Okay, I found PC, and then we'll just keep resetting him. Okay, thank you. All right, Joseph Burnett.
Medical reset.
Okay.
And, Your Honor, I'm just
Same?
going to make the same request. And
Okay, Mr. Reedy, your response? Okay, yeah, I mean, these are all, it looks like either, these look like all KPSs anyway. So, all right, I will find probable cause, and we'll see if we can get him back into, or Mr. Burnett back into court at some point. Okay, anything else?
no.
Yes, sir. Any other orders that you need? I think all the jails look empty. All right, I'm going to turn off the record.